So my name is Daniel German, and I'm probably the only Mexican in the entire workshop. And I used to go to high school relatively close here, and there was nothing, absolutely nothing around here. This used to be garbage dumpsters. And you can see now the development of the city. And one of the areas where I have specialized in my career is the influence of intellectual property in the process of software development, particularly copyright. And the most specific use of that is open source software development. And so in the last few months, I've been looking at the current legal situation in AI systems. And so I'm going to give you a small overview of that. And if I have learned something from lawyers is that I should have a big disclaimer at the beginning. And so I'm not a lawyer. I'm informed in it, in the process, the laws, etc. And but the other thing I have tried to do is, in this presentation, I'll give you original sources. I will not go to articles or newspapers because frequently they get concepts wrong. And the other thing that is also very clear is that many aspects are national in scope. So what happens in one country has no relevance in a different country. So I'll also try to clarify that. And I will also clarify the portions that they are my opinion. So you can kind of distinguish between what I consider fact from what I consider my personal view with respect to these issues. One of the advantages of staying awake during the presentation is that you will have plenty of discussions about this with people. And because there is a lot of misunderstanding about these issues. But one way or another, everybody will be affected. And because we are all using, I suspect most of us are using ChatGPT. So what does it mean to use ChatGPT in the context of who owns what is created, for example, okay? And this is not a presentation about many laws, including data privacy. I'm just going to concentrate on intellectual property, okay? There are lots of legal issues that intersect in the area of AI and machine learning, so I'm not going to touch on those. And so I'm going to give you a very brief intro to intellectual property because I will not make any assumptions. So at least you know what I'm talking about. And intellectual property is divided into four main types of protections. Copyright, trademark, trade secrets, and patents. And there are many slight differences across countries, but these are the fundamental four that we have. And so copyright protects expression. Everybody can write stories about superheroes, but we cannot copy from one to another. Copyright is perhaps the most important protection of software. Okay? Every time that you write software, the moment that you put it in a medium that is tangible, you get that protection. Okay? In most countries in the world, you don't have to register anymore, unless, for example, in the United States, you want to initiate a legal lawsuit, then you have to have that registration before. Okay? So the moment that you create it is essentially protected. Trade secrets. This has been also very important in our industry. Trade secrets are secrets that stay secret, and the law protects that secret as long as you keep it secret. Okay? As long as you do everything in your power to keep it secret, usually this gets translated into non-disclosure agreements. And in part of your research, you might get involved into some of this, that you might only be able to go into a company if you sign a non-disclosure agreement. That's essentially the protection of these trade secrets. The most famous one, of course, is Coca-Cola, right? Trademarks protect the marks, the logos, the colors, the symbols, and of products, okay? So again, Coca-Cola is a good example. Another one that is relevant to our industry is Firefox. So Firefox, many years back, had a lot of restrictions with respect to how it could be further distributed by distributions. And Debian decided that their distribution did not was not following those restrictions. So they had to remove the trademark of Firefox, all the logos, etc., and created an equivalent called IceWhistle. Okay, so the Mozilla Foundation has tried to use trademarks as a way to protect their mark, including Firefox. Patents, on the other hand, they protect inventions. And inventions is a new way of doing something or creating a new solution to a problem that already exists. Many years ago, there was a big debate of whether software could be patentable. Now that discussion doesn't exist anymore. Perhaps one of the most famous patents, which is now in the public domain, is the Amazon one-click shopping process, okay? Okay, so let's now come back to our environment and let's talk about the main challenges. And so actually, there should be 4. So 4 main stakeholders. We have the data owners, the ones that own the data that is being used for training. Then we have the people that do the training. And most of the time, the ones that do the training are the ones that do the operation. But I try to separate them here because in many cases, we can acquire models that have been already trained by somebody else. So there's that slight distinction between one and the other. And then, of course, the users, and particularly the ones that use generative tools. Because if you're just using a prediction algorithm, then the issues are very simplistic. It's when you generate content that many of these appear. So let's go through the data owners. So the fundamental question that we are concerned about these days is who owns the data that is being used for training. And so my big statement is that without data, machine learning and AI systems are useless. They have absolutely no value. And the owners of the data are recognizing this. So they want a piece of the action. And in most cases, with very few exceptions, data has an owner. Somebody has the copyright or other protections on that data. But most of the time, we're talking about copyright protection. So that means that the owner of the data can restrict who can make copies of that data. And of course, in the process of training, in the process of creating data sets, the copying exists. So that's a very, very important concern. Collections of data can also be protected. It's like an umbrella on top of it. In some countries, they are called database protections. And so each one of the individual items might be protected by different individuals. And then the umbrella, you can think of it as the wrapper, is a different ownership. Okay? So that also creates very interesting layers of potential ownership where it's not only the first person that we encounter, potentially the owner of the data set, but also behind that there might be owners of each one of the individual items of information. So what are the concerns of the data owners? So most of the time, this is what you hear, that the works are used in an unfair manner. I'll talk a little bit about why we use the term fair, unfair, because it's also based on US law. But essentially, the owners are saying, ChatGPT is worth billions of dollars. But without data, ChatGPT is nothing. So we want a piece of the action, essentially. And, but there are also some interesting aspects that come with it. Like, for example, if my job is to take photographs for advertisement, and suddenly ChatGPT uses the photos I have already taken to create new photos for potential customers, it's potentially affecting my market by doing that. So I will have less customers that buy my photographs because now they can generate it potentially with my own photos without contacting me. Okay? So that's one of the, that's the issue when we talk about loss of market. And of course, you probably have also heard of this, is if my data is used for training, then I own a little piece of the output. This might actually be more tangible in images, when you can actually see a similarity, or in source code, when you can say, yeah, I can kind of see the original source code here and there. Okay, so that has also been a very important concern of the owners. So let me talk about specifically countries. So I put a little flag here so we know whether I'm talking about something generic or we're talking about something specific. So in Japan, the current law basically says that it's permissible to exploit any work without compensation to the authors that is done for data analysis. So essentially, the law, a few years back, 18, if I remember correctly, decided that this was a good idea. And that's currently the situation, okay? However, now there's a lot of discussion because now the owners of the data say, wait a minute, in 18, we didn't have all these technologies available. So there's now a lot of revision in the law. Well, there's discussion and potential revision of the law that is going to happen, okay? You might have seen this pair of photos in articles in newspapers. This is extracted from the actual lawsuit. The photograph on the left-hand side is owned by Getty Images. Okay? They are the copyright owners of this photograph. And the interesting thing is that this is the Getty Images trademark. Okay? The way that they protect their label. And this is the way of saying, this photo is ours, and if you want it without a trademark, you have to pay us to be able to do that. These are the claims that we have in the lawsuit. So they're essentially claiming that there is copyright violation in an enormous scale. Essentially, all the scraping of the photographs, the analysis of those, well, basically the copying of those photographs. In many cases, actually in all cases, without the permission of Getty Images and violating the terms of use of the website of Getty Images. Okay? This is the point that I mentioned a few minutes ago, that Stability is competing in the same market with Getty. Because if somebody has an article that they want to have a picture for it, in the old days they could actually go to Getty and say, give me a license for that. Stock Images is owned by, iStock is owned by Getty. Okay, so they are in this market and they feel like Stability is replacing it. And then this is actually, see this thing here? Let me see if I can make it a little bit bigger. No, I can't. It doesn't zoom. The logo of Getty appears in the copy, but it appears all distorted. Okay? The interesting thing with respect to this lawsuit is that it's not only about copyright, it's also about the contract of using the website, and perhaps more importantly, also about the trademark. Okay? And there's a clear relationship between the copy and the origin. So we can see that direct linkage. Okay? Versus potentially having millions of potential documents that we cannot identify how each one of those documents contributed. Okay? So we don't need explainability here. It's obvious that one image was used in the other. Okay? You might also have heard of this lawsuit, DOE against GitHub. This is a class action lawsuit, essentially bonding together lots of developers. That's their goal. And these are the essential claims that they are making. That Codex and Copilot are using copyrighted materials without permission, in frequently violating the terms of the license on which they are. The traditional worst case scenario is like, we had GPL code and you're creating code without that license. So that's the fundamental problem. I took the liberty of copying the code from the lawsuit. If one of my students gave me this code, I will think they are some of the worst in my class. Okay? Because to have a function that does all of this used to determine if an integer is even, is just a waste. Okay? And so this is the code that comes from, which one is the one? Sorry, the left-hand side is the original code. The code on the right is the generated code. The interesting thing is that in the lawsuit, it doesn't really matter that it's bad code. What matters, perhaps even better, is that it's so bad code that the developer will never create it. So it's more obvious that it actually comes from that original source. Okay? Let's go to Sarah Silverman, Versatability. The interesting thing is that these two lawsuits are actually by the same set of lawyers, the same law firm. So they're creating 3 class action lawsuits. The next one I'm going to talk about is also managed by them. So here's also again the issue of derivative works, that the works that they created have been used to create works based on them. And also the issue of access and copying of those works. The thing I find very interesting in this lawsuit is this: Anderson relies on the output of a search of her name on the I have been trained site to support the plausibility that there's a copyright infringement. At this point, the only thing that has been decided is that this is sufficient evidence to continue the lawsuit. Okay? I think that the implication of this is that the ones who are doing the training are going to obfuscate more and more the data that they are using to avoid these obvious cases where people can actually verify that they have been used for training. Creating data sets. Creating data sets is also a big, big issue. Does the creator of the data set have the right to scrape the data from its origin? Most of the time, the answer is that they probably don't care. They just run their spider and they download data. And so what is actually in the distributed data set? That's actually a very interesting question. Does it contain copies of the work? In many cases, the claim is, particularly with images, that the data sets contain very, very small renditions of the original. But in the case of text, it's mostly the original text that they find in the original site. Perhaps without the formatting, but it's more of a clear copy. The other thing is actually copying the metadata of work. And so, for example, in the case of Getty versus Stability, Getty argues that that metadata, in fact, that's actually the old field in the IAMG. This metadata that describes the figure is copyrighted, which is totally true. And so they're actually copying data that Getty owns and distributing in the data set. Okay? That's actually the case with the Lion data set. They don't distribute the images, they distribute the URLs, but they distribute the alt metadata with it. So that's essentially the argument that Getty is actually making. This is opinion. I think that of the lawsuits I have seen, this is the most likely to succeed. Because, first of all, Getty has very good lawyers, and is the best written, in my opinion, of the ones I have read. But again, I'm not a legal expert, so that's just my opinion. Okay, let's go now into the side of training. So training, so I mentioned Japan. Germany has a similar law. It's permitted to reproduce lawfully accessible works in order to carry out text and data mining. The key sentence here is accessible works. And essentially means that as long as you don't have on your website the metadata saying don't crawl this site, they can use it. Okay? So it also brings a very interesting question with respect to if I want to protect my data from this kind of analysis, then what do I have to do? Okay? Now remember, this is in Germany, so there's a big argument with respect to, oh, maybe I can do it in one country, and the training, and then I can do the operation in another country. BlackBerry tried to do something similar by arguing that most of the processing was done in Canada, and therefore in the big lawsuit that they had, that cost them billions of dollars, and therefore it didn't apply to the United States. But the United States court said it doesn't matter where you do it as long as you have customers in the United States. So I think that what's going to happen is that it depends on where you want to do your business, and where you're doing the analysis. You have to consider both of them, the intersection rather than the or one or the other. Okay. So I mentioned fair use towards the beginning. So in the United States, and fair use is essentially the ability of individuals and companies to make copies without the permission of the owner. And this is a bedrock of the copyright law in the United States. And the courts have decided in this four-process method to evaluate whether a use is fair or not. And I put up the basic statements here. The purpose of the character of the use, the nature of the copyrighted work is different to make small excerpts from a book than to copy an entire photograph, for example. The amount and stability of the portion taken, and the effect, this is actually also very, very important, the effect on the potential market, okay? I'm going to actually talk, when I go into more of my opinion, I'm actually going to talk about some law cases that have used effectively fair use to make copies of copyrighted material. Okay, so is the training fair use? Nobody knows. So all these companies have mentioned Stability, OpenAI. They have not disclosed completely their strategy because all the lawsuits are in a very early stage. At this point, what they're basically trying is to throw them and saying that lawsuit cannot continue because there's not enough foundation for it. And for example, in the Sarah Silverman, the judge said, claim this, and this, cannot proceed, but I'll give you the chance to submit them again, okay? So we don't really know how each one of these big companies will defend their position. We know the position of Getty Images because we can actually read it because those are the ones with the lawsuit. So it will take some time. And unfortunately, it will actually take years for that to be resolved, okay? And I think, and this is again my opinion, so I think that these are two cases that they're very interesting with respect to this. You probably remember the case of Sun Microsystems, then becoming Oracle, that sued Google for copying the API of Java. Okay. The interesting thing is that Sun/Oracle won that lawsuit. APIs are copyrightable in the United States, but Google won the fair use. So they can use the API without having to compensate Google. So it's like both of them won in a way. But I think that the victory of Oracle was Pyrrhic. They invested a lot of money and they didn't actually get much out of it. The other one is Google Books. Google Books is also an interesting exercise. And I have excerpts from both of them. And so this is actually the decision. This went all the way to the Supreme Court. And it's actually very interesting reading. They have very knowledgeable people, and there is very, very nicely explained. In general, the Supreme Court decisions of the United States, they're enjoyable, and we learn a lot by reading them. And so it was a fair use of the material as a matter of law. Okay? So that was actually very, very important because it basically said, okay, we lost the war, APIs are copyrightable, but we can always claim, well, not always, we can claim fair use. This is another very important aspect. Fair use is decided case by case, which actually means that you might have a very solid case for fair use, but that doesn't stop somebody to take you to court and you have to spend money dealing with that. That's actually a big disadvantage. This is the final decision for the Google Books. There's one thing that I actually find very interesting. So is all the benefits. They measure all the benefits that Google Books have. So we can argue the same about AI. There are a lot of benefits that AI has. But one thing that they mention very clearly in Google Books is the benefit in the market of the books. They said the people is searching for something, find that it's in book X, so therefore they can go and buy book X. And Google provides a link so you can go and buy it. So I think that that's actually an aspect that it's going to be a little bit tricky for AI. Again, this is opinion, okay? Okay, what about operating the AI? And there is the claim of copyright infringement. And this is the case against OpenAI, Silverman. And it's called vicarious copyright infringement. So that's the case where the user actually does it. So if you think about it, the copy doesn't exist until somebody asks for it, until the user says, create me such. So the argument that is being made is that OpenAI is helping the users to commit copyright infringement. Okay, that's one of the many arguments. The other one is that the creations are derivative works. Okay, and but the most important one is this vicarious copyright infringement, that the operator of the AI will have to worry about that. Okay. What about using an AI, ML AI? Well, I think that the first one that, and maybe we don't notice this because we are academics, is trade secrets. If my source code is trade secret, I cannot give it to an AI for training that is owned by somebody else unless I have a non-disclosure agreement in advance. Okay? That's the way that a lawyer will tell you. Unless you have the ND, don't give it to anybody who's not a member of the organization. Okay? And I think that this is actually going to be one of the great challenges of how to deal with trade secrets in this environment. The non-disclosure agreement. What about retraining unsubmitted content? And I have a colleague at my university. She's worried about her ideas of her research being leaked into ChatGPT and offered to others. Okay? It's kind of similar to the trade secret, but it's similar and different because there's no actual protection that she has. It's just this worry that is in her mind that she might actually interact in a way that it's not different than many academics talk to another academic hiding some of the knowledge that they have, right? And so I put the terms of use of OpenAI. So in general, they will actually, we might use content to provide, maintain. So content is content that it generates, but also the content that you provide. And they said by default, we will use it. This is the prompt version. We will use it for retraining. But you can actually opt out. You can tell us that you don't want that to happen. Okay? So that's a little bit of an advantage in that regard. This is something that every one of us should actually go through, the terms of use of these tools. The terms of use of OpenAI just changed days ago, okay? Who is the owner of the generated work? What kind of claim do I have on that output that I got, okay? So, and this depends fundamentally on two things. One of them is contract. What does OpenAI or any other tool, Midjourney, says about the created content, okay? And the other one is, what does the law say about this? Let's look at OpenAI. So OpenAI takes a very, very liberal approach. It basically says, to the extent permitted by applicable law, you retain your ownership rights on input and own the output. You said, we don't have any claim on that. You own that, okay? In fact, yesterday they just announced this. It's blurry. We still don't know. I haven't read the document. I haven't been able to find an actual document. That they're actually introducing the corporate shield, which basically says that they're going to defend anybody who is sued for copyright infringement for some data that might have been used for training. How is it going to happen? I do not know. And same with the similar protection that GitHub is providing. It's not very clear what are the conditions under which this will apply. Okay? GitHub Copilot. GitHub does not claim any ownership rights on suggestions. It's very blurry. It doesn't even say you own it, you don't own it. It doesn't even want to touch that. Okay? So it's much more. And of course, you retain ownership of your code. That's kind of expected. Midjourney. It depends on whether you pay or not. Okay? So if you pay, you have the right. If you don't pay, they own it, and they give you a Creative Commons license on the creation. Okay? So as you can see, it varies tremendously from one of the major AIs to another. In the United Kingdom, everything that is computer-generated content is owned by the operator. The law doesn't clarify what the operator says, so it actually have to be dealt case by case. But that removes the ambiguity. If you use any kind of program to generate content, you own the copyright on the created content. In the United States, it has clarified. This is a document published by the Copyright Office. Essentially, the argument is that only human creations can be copyrighted. And AI-generated content is not created by a human. Okay? So therefore, it doesn't have copyright protection. The typical argument is that, what about the prompt? The prompt is how I actually create it. So I'm the one creating it via the prompt. And the Copyright Office has made the analogy to talking to an artist. If we talk to an artist and say, oh, I want a sculpture that has this and that, and remove this, you don't own the sculpture. The sculpture is still owned, the copyright, by the person creating the sculpture. Okay? So that's the analogy that it's making. This is also a very famous image in the United States. The image on the right bottom, won a very small award in the south of the US. And originally, the author submitted copyright registration for this image. But then he also said, he went claiming everywhere, I generated this with generative AI. So the Copyright Office, reading the news, revised the copyright registration and denied it. So remove the copyright registration of this. That means that the image is in the public domain. This probably is going to be continue to be argued in appeal, but currently the decision is that the original generated image, as you see above, is most of the work. So what the author can say is, I do not know Midjourney image, I own the small pieces that I added to it. But the author does not want to say that. At this point, the author has refused to explicitly state what modifications he made to the image. Because the Copyright Office says, you own those little things, but you don't own the major pieces of work that they are being generated. He also used several tools, because he generated the first image, and then he used other AI tools to generate more high-definition sections of the final product. Okay? So there's a lot of interaction of different tools. But he has refused to specify how he used all these tools. Okay? Thaler is a prof in the US. His goal is to make AI recognizable as a person. He has several lawsuits regarding this. And one of them is that he wants to make this image owned by him and the AI. And the Copyright Office says no. The creator of an image, and therefore the owner by default, has to be human. Okay? So he's challenging this. And this is actually a very interesting statement from one of the documents. Human authorship is a bedrock requirement of copyright. Okay? So it'll be interesting to actually follow this. At this point, he has lost, but he has the chance to appeal. And so he might continue on this quest. So what to do? So this is my opinion, and I'll just go quickly through this. And I think that ultimately, with respect to ownership, it's not going to be different than photography. Originally, photography was perceived as having no intellectual value. You put the camera, press the button. It was until beep, 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 beep. What is flashing? I can still see it in my computer. Let me reconnect it and then hope for the best. Something is rebooting. Mira, este sí me lo detecta porque lo desconecto y cambia, lo vuelvo a conectar y cambia. Pues no pagaron especialmente para que... So Ahmed, we lost electricity. Anyway, so if you have questions, so I'll talk a little bit about what to do, but with respect to what I've talked already. I talked to bigger audiences. Oh, this because you're recording, right? Okay, so. Yeah, you're recording, so sorry. Any questions? Well.
So with all these lawsuits going back and forth, and with nobody knows what's going to happen with all this new technology, I wonder what kind of input does our community, the technology community, have on the outcome of these laws and lawsuits?
Yeah, that's a very good question. So for example, in the United States, there's currently a forum. So the Copyright Office of the United States has asked for comments. So it has issued a set of questions. I don't remember the exact number of questions. And then anybody, literally anybody, can submit an opinion to the Copyright Office. I think that's a very important one. A lot of those opinions are basically people just going and filling the form and saying, AI should not be allowed because I own. Other people say, AI should be allowed because it's this. But I think that if you answer properly the questionnaire, not necessarily all the questions, just few of them, then it has more value and they will take it more into consideration. But yeah, there's already a lot. They extended it. For example, Microsoft has already filed, Getty Images has filed, and it will be interesting to see the contrasting view of both, because one of them want to protect the rights of the owners. They don't want to limit AI. What they want is compensation, most of them. Okay. Now the other thing that happens is that Getty and Adobe had joined together to create generative AI, and the way that they're selling is like, we're the legal one. So they're actually now competing against OpenAI and other similar technologies. So it's going to be a fascinating environment. Okay. Yeah. I think so. I can see it here. Not anymore. Ya lo puedo ver aquí en la... Bueno, lo veo y se va, viene y se va. Viene y se va. Need to get your refund.
Yeah. I was just waiting for
Yeah.
them to resolve.
Sorry, go ahead. Yeah.
What do you feel is the most important legal decision or consequence to come out of this in the long term?
I think that the Getty is going to be very important, because I think that the other three are not to the same level of detail. We can see it. We can see the original image and we can see the derived image. There's no question about that, right?
Right.
We don't need explainability. And Getty is in the same market that Midjourney is trying to actually enter. So I think it's going to be very interesting, and I don't doubt that it will go all the way up. But it will take 5 to 8 years for that. The other interesting aspect is that The Copyright Office in the United States has always been concerned with moving forward the technology and the arts. So I think that what might happen in the long term is that the legislatures will actually change the law to basically say AI is allowed under certain circumstances. And the use of data for training will be allowed under certain circumstances. And perhaps the biggest restriction is to say you can opt out from the training. I see that as a very natural consequence.
Okay.
Yeah.
Thank you.
Yeah. Anybody else?
It's free.
Well, we'll give it 2 minutes, and if not, then I'll just finish via voice, and then you can see the presentation later. At least my computer didn't fail me, so I'm happy with that.
Okay.
Yeah, go ahead.
So I have a question about the data owners. So in a case, like the data created by the end user, for example, the user of your mobile apps. So in this case, do the user own the data, or is different between different countries? Like what's the definition of the copyright?
So the copyright is more or less the same all across the world, because the World Intellectual Property Organization has, it's coming back to life, and it's like a robot coming back slowly. And the World Intellectual Property Organization is basically defines the foundations for that. Okay. What is different is the details, like what I show about Germany, what I show about Japan, the United States. For example, fair use doesn't exist in Canada. It doesn't exist in the United Kingdom. They have fair dealing, which is much more restrictive than fair use. So there's also going to be very interesting to see lawsuits in each individual country to actually deal with this. And, but my opinion is that essentially just a minefield. Yeah. And I think that for the major operators, especially because they have so much money in stock value, there's going to be a lot of lawsuits because they perceive that they have money to extract. Okay? If you are running a machine learning AI system, they're probably not going to go after you because what's the point, right? But OpenAI is very, very valuable today. Okay, so if you're owners of data, what do? So you can use other laws to protect them. One of them is contract law. So if you have a website with data, put very explicit terms that say you cannot use this data for training. You cannot scrape this data. That's a way that you can actually protect against that. It makes me think about my Mexicanness, but that's a different story. Trademarks is another way to actually protect. I think that that's a very solid foundation for Getty Images, that the trademarks are so visible and they had to be removed, or in this case, even just altered. So then you have an intersection of two different laws. Actually three, so contract, copyright, and trademarks. See? So one or the other. The creators of the data sets, I think that a very, very important aspect is to clarify. Actually, let me switch to the other one so you can actually see a little bit more. So now that we have. So I'm almost done, so. Let's move it down. Creators of data set. Clarify the license of the data set. Okay? Clarify what permission, what you own and what you don't own. Because they're very, very ambiguous. They're very, very blurry. Yeah? Okay. Now how do I go back to my presentation? I think that let's just continue here. And clarify the relationship to the license of each one of the individual items of information. Okay? Because there is a paper recently that went through a lot of data sets and they just found that there's a mess in most of them. They don't have actually clear terms of how they can actually be used. Those training, so evaluate the risk of using a data set. And so for example, I will avoid training or Getty images, right? So it's actually one of those obvious things. Document the traceability of the data, but at the same time it's a little bit risky because if you publish this traceability, that might come back to bite you. Okay? So this is a sword of two edges in that sense. And then also clarify whether your training model was created with the permission of the data owners, because that might be the case. You might have a data set that everybody's perfectly fine to use for any purpose. Because perhaps you own the data, and then you're giving that permission to anybody who wants to use it. Those operating the train model, those are the ones who are at the biggest risk at this moment. But I think one important one is just to clarify the terms of use, and for the users to also read them. Okay, and that's actually so. Check the terms of use. That would be my first suggestion. Read what you own, what you don't own, whether the prompts and the data that you're providing are being reused or not. And also discuss, so if I was an organization, I will discuss with my lawyers how to document what the AI generated from the rest of my code. Because at the end of the day, a software system is a combination of human-created and perhaps machine-created. But it's going to be impossible to separate. So that might be in the public domain, the computer-generated, but it's so intertwined with the rest that doesn't really matter. But it's good to actually say from here to here it was generated. So that is in the public domain. But the rest of this file is mine. Okay? Images are going to be tricky, because the unit of content is very, very different than a software system. Okay? So I think that images are going to have their own concerns and discussion. So these are my closing words. I think that what I have shown, if you have to if you want a take-home message, is that there's uncertainty, and there's going to be uncertainty for many years to come. And so we need to learn to operate in this environment. And finally, I think that these discussions that I mentioned in the answer with WIPO and the country copyright offices are going to actually start to change laws that adapt to the use of machine learning, either to say you can only do it if you pay. For example, in Canada a few years back, when we used to use burnable DVDs and DVDs, we had to pay extra cents for every unit. And that money was distributed across musicians in Canada. That was kind of the balance that the government of Canada found between one and the other. It's possible that this is going to happen, that the Authors Guild will get an amount of money, and then everybody who belongs to them is going to be happy because, well, maybe not happy, but will have to accept that they get few cents every year for this. Okay? So, but again, so these are the things that will happen as the time passes by, and as we start to actually see the resolution of some of these lawsuits. Okay, and the forum. So I think that the forum that the Copyright Office in the United States has is going to be very important. Last year it was WIPO. WIPO had the same, but WIPO doesn't create law. So WIPO basically just issues some guidelines and concerns. It actually issues concerns about all of this, but not necessarily solutions. I think it's actually a very tricky environment. Okay, and that's basically all. So thank you for your time.